Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. A quorum is present. A quorum is present. A quorum is present.
A quorum is present. The clerk will report the motion to invoke cloture.
Cloture motion, we the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, do hereby move to bring to a close debate on the nomination of Amy Coney Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States, signed by 18 senators.
Pursuant to Rule 22, the chair now directs the clerk to call the roll to ascertain the presence of a quorum.
Mr. Alexander, Ms. Baldwin, Mr. Barrasso, Mr. Bennett, Mrs. Blackburn, Mr. Blumenthal, Mr. Blunt, Mr. Booker, Mr. Bozeman, Mr. Braun, Mr. Brown, Mr. Burr, Ms. Cantwell, Mrs. Capito, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Cassidy, Ms. Collins, Mr. Coons, Mr. Cornyn, Ms. Cortez Masto, Mr. Cotton, Mr. Kramer, Mr. Crapo, Mr. Cruz, Mr. Daines, Ms. Duckworth, Mr. Durbin, Mr. Inzi, Ms. Ernst, Mrs. Feinstein, Mrs. Fisher, Mr. Gardner, Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Height-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Leffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters.
What do you want to say? Yeah, that's what we told them. Mr. Peters. 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 Mr. Peters.
Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
A quorum is present. The question is it the sense of the Senate that debate on the nomination of Amy Coney Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States shall be brought to a close? The yeas and nays are mandatory under the rule. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. Mr. Barrasso. Aye. Mr. Bennett. Mrs. Blackburn. Aye. Mr. Blumenthal. Mr. Blunt. Aye. Mr. Booker. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher.
Aye.
Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blackburn, Blunt, Bozeman, Braun, Burr, Capito, Cassidy, Cornyn, Cotton, Kramer, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Gardner, Graham, Grassley, Hawley, Hoven, Hyde-Smith, Inhofe, Johnson, Kennedy, Lankford, Lee, Loeffler, McConnell, McSally, Moran, Paul, Perdue, Portman, Risch, Roberts, Romney, Rounds, Rubio, Sass, Scott of Florida, Scott of South Carolina, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Senators voting in the negative: Baldwin, Casey, Collins, Duckworth, Durbin, Heinrich, Hirono, Jones, King, Klobuchar, Leahy, Manchin, Murkowski, Murphy, Murray, Peters, Reed, Sanders, Schatz, Smith, Udall, Wyden. Ms. Warren, no. Mr. Schumer, no. Mr. Tester, no. Mr. Coons, no.
From a previous.
Ms. Cantwell, no. Mr. Blumenthal, no. Mr. Markey, no. Mr. Cardin, no. Ms. Stabenow, no. Mr. Kane, no. Ms. Hassan, no. Mr. Whitehouse, Mr. Whitehouse, no. Ms. Rosen, no. Mr. Van Hollen, no. Ms. Cinema, no. Mr. Menendez,
He's gonna go home after.
no. Mr. Booker, no.
Here between 8 and 10, and then I'll come back anytime between.
Ms. Cortez Masto, no. Mr. Warner, no. Mr. Brown, no. Mrs. Feinstein, no. Mr. Carper, no. Mr. Bennett, no. Mr. Markley, no. Mrs. Gillibrand, no. Mrs. Shaheen, no.
On this vote, the yeas are 51, the nays are 48. The motion is agreed to.
Madam President,
The Majority Leader.
could we have order in the Senate?
The Senate will be in order. The Majority Leader.
So, Madam President, let me begin this afternoon with the following quote. Few men in society will have sufficient skill in the laws to qualify them for stations of judges. And the number must be still smaller of those who unite the requisite integrity with the requisite knowledge. That was Alexander Hamilton in Federalist 78. Now, the framers knew the independent judiciary would be a crucial part of this new experiment in self-government. If the separation of powers was to endure and the people's rights were to be safe, we would need individuals of the highest quality on the courts. So how fortunate for our country that the Senate just advanced one of the most qualified nominees for judicial service that we've seen in our lifetimes. Judge Amy Coney Barrett of the U.S. Court of Appeals for the Seventh Circuit is a stellar nominee in every single respect. Her intellectual brilliance is unquestioned. Her command of the law is remarkable. Her integrity is above reproach. First, as an award-winning academic and then as a circuit judge, she's worked her way up to the pinnacle of the law. But just as importantly, Judge Barrett has displayed zero willingness to impose personal views or clumsily craft new policy with her gavel. She's demonstrated the judicial humility, the neutrality, and the commitment to our written Constitution that are essential for this office. By now, Madam President, as tends to happen by the end of these processes, the Senate knows Judge Barrett very well. Senators saw the Judiciary Committee put the nominee through her paces with days of exhaustive questioning. We've been able to study nearly 100 opinions she's issued in 3 years on the federal bench. We've had another opportunity to examine the 15 years of scholarly writings that most of us reviewed 3 years ago when Judge Barrett won bipartisan confirmation to her current job. And we've been deluged by personal testimonies from every corner of Judge Barrett's career and life to confirm just what a remarkable person this nominee is. One of Judge Barrett's former colleagues at Notre Dame is a leading expert in comparative constitutional law. That means he studies the courts and constitutions of countries all around the world. He meets judges from across the planet. Here's what this expert says about his colleague. I have had very many occasions to meet, observe, and work with high court judges from all over the world, from Argentina to Austria, from South Africa to South Korea. And I can say with great certainty that Judge Barrett stands out on a par in her abilities with the most distinguished of them all. He goes on to say her legal work is erudite as it is clear and accessible, and as honest and fair-minded as anyone could aspire to, with not a hint of personal bias. Now, most of us would be thrilled to receive such praise once or twice in an entire career. But Judge Barrett seems to provoke this reaction in absolutely everyone. The highest professional compliments seem to be the default reaction of anybody who crosses her path, anybody who comes in contact with her. 81 of her law school classmates from diverse backgrounds, political affiliations, and philosophies say the nominee embodies the highest caliber of intellect, fair-mindedness, empathy, integrity, humility, good humor, and commitment to justice. They also said, as fellow students, we've learned more from Amy than the professor. Learned more from Amy than the professor. 3 years ago, more than 70 fellow scholars wrote the Senate calling her scholarship careful, rigorous, and fair-minded. They said her personal integrity earns wide respect. And listen to this, every one of the Supreme Court alumni who clerked alongside Judge Barrett wrote us to share their unanimous view that she is a woman of remarkable intellect and character. That means, colleagues, that was the clerks to Ginsburg and the clerks to Breyer as well, all of them, without exception. Now, how did that clerkship come about? By the way, after one of her professors, who's now a university president, wrote Justice Scalia with one sentence, Amy Coney Barrett is the best student I ever had. But before she clerked for the Supreme Court, she clerked for Lawrence Silberman on the D.C. Circuit, who by his own admission is an Ivy League snob. And he got a call one day from a professor at Notre Dame, and he said, you know, I know you only take clerks from mostly Harvard and Yale, but this is the best student I ever had at Notre Dame. And so this Ivy League snob decided to take a chance on somebody who didn't go to Harvard or Yale. That was Amy Coney Barrett, and then he called his good friend Nino Scalia, and he said, goodness gracious, you don't want to miss this opportunity to have this clerk. So we've got here a uniquely qualified person. And the best evidence of it is you don't hear anything over there about her qualifications. Not a peep about her talent, her intellect. We've got, colleagues, the perfect nominee for the Supreme Court. A few weeks ago, Harvard law professor Noah Feldman, who leans left, wrote that Judge Barrett is a brilliant and conscientious lawyer who will analyze and decide cases in good faith. He said she meets and exceeds the basic criteria for being a good justice. So, as I was saying, no matter all the acrimony that swirled around the process, nobody's attempted to dispute Judge Barrett's qualifications. To the contrary, no one can help being impressed. At one point during Judge Barrett's hearing, she was asked about an arcane legal doctrine. Her answer was so clear and so accessible that one of our Democratic colleagues, I won't name him, I don't want to get him in trouble, had to remark, quote, that's quite a definition. I'm really impressed. Well, so are the American people. Some opportunities, some opponents of this nomination come right out and say, quote, it's not about qualifications. They deserve some credit for being honest about it. They say they aren't interested in whether Judge Barrett will smartly and faithfully apply our laws and our Constitution. They aren't interested in that. Instead, they want to make apocalyptic predictions about policy. Well, there are a few problems with that. One is that their political side has been shopping the same horror stories for 50 years. They've been saying the same thing for a half a century about every Supreme Court nominee by a Republican president, without exception. And many of those judges, not to the delight of some people on this side of the aisle, went on to not disappoint the other side, which shows you how hazardous it is to predict what someone will be for a lifetime. Many have been surprised, some unpleasantly. It's almost as if jurists are not politicians with policy platforms. It's almost as though that's the wrong way to look at it. That is a deeper misunderstanding of what's at play here. Let me quote an expert. A judge must apply the law as written, not as she wishes it were. Scalia used to put it this way. He said, if you want to make policy, why don't you run for office? That's not what we do here. That's not our job. It takes a good deal of discipline to squeeze your personal opinions out of your decision making. That's the kind of judges we've been confirming here for the last 4 years. People who are sworn to uphold the law and take it seriously. President Obama once said he wanted to appoint judges who had empathy. Think about it for a minute. If you're the litigant for whom the judge has empathy, you're probably in pretty good shape. But what if you aren't? That's not what we've been doing here for the last 4 years with the judiciary. And the reason that frightens these guys on the other side so much is because that's exactly what they want. Another branch of legislators seeking outcomes that may or may not be reflected in the law or the Constitution that's before them. It's exactly what they want. Courts have a vital responsibility to enforce the rule of law, which is critical to a free society, but the policy decisions and value judgments of the government must be made by the political branches elected by and accountable to the people. The public should not expect courts to do so, and courts shouldn't try. Now, who said that? That was Amy Barrett who said that. She understands the separation of powers far more keenly than her critics. She understands the job of a judge. Our Democratic colleagues should not have tried to filibuster this exceptional nominee. They should have listened and actually learned. I loved during the hearing when Senator Cornyn said, "What do you have on your notepad?" She held it up, nothing. Nothing. No notes at all. And we got 2 former Supreme Court clerks on that committee, Senator Cruz, Senator Hawley. And I've heard them say over and over again, 3? Oh, Mike, sorry. 3. So they've been around the best at the highest level. Nobody's seen anything better than this. This is something to really be proud of and to feel good about. We made an important contribution to the future of this country. A lot of what we've done over the last 4 years will be undone sooner or later by the next election. They won't be able to do much about this for a long time to come. Fortunately for Judge Barrett and for our nation, history will remember what is already clear. The deficiency is with their judgment, not hers. Their judgment, not hers. The Senate is doing the right thing. We're moving this nomination forward, and colleagues, by tomorrow night, we'll have a new member of the United States Supreme Court.
Madam President,
The Senate will be in order. The Senate will be in order. The Democratic leader.
thank you, Madam President. Now, I want to start today by talking about some breaking news that may at first glance not seem relevant to today's proceedings, but in fact is a perfect illustration of how broken this process is. We find ourselves in the middle of a pandemic that the Republican Party has never taken seriously enough. Can we have order, Madam President?
The Senate will be in order. Please take your conversations out of the chamber.
As I said, the Republican Party has never taken this pandemic seriously enough, and it's a pandemic that's worsening by the day. According to Dr. Fauci, the nomination ceremony for Judge Barrett was a super spreader event. Today, the White House Chief of Staff conceded the White House is, quote, not going to control the pandemic. And yet, last night we learned that several aides close to Vice President Pence have tested recently positive for COVID. Now, we wish them and their families well. We wish the Vice President and his family continued health. But a normal response after being close to several people with COVID-19 would be to follow CDC guidelines and quarantine for everyone's safety. But this is not the case. In the same breath with which they announced that Vice President Pence was exposed, the White House said that he would keep on campaigning, comparing campaigning work to the work that doctors and nurses and firefighters and police officers do. It's a puzzling claim, especially since the Vice President failed at the most important official duty in his portfolio, the White House Coronavirus Task Force. Not only has the White House Coronavirus Task Force failed to keep the American people safe, it has even failed to keep the White House safe. Even worse, the Vice President reportedly intends to come to this chamber tomorrow to preside over Judge Barrett's confirmation vote. The Vice President, who's been exposed to 5 people with COVID-19, will ignore CDC guidelines to be here tomorrow, putting the health of everyone who works in this building at risk. It sets a terrible, terrible example for the American people. And nothing could be a more apt metaphor for what's going on here. The Republican Party is willing to ignore the pandemic to rush this Supreme Court nomination forward. And the Vice President, after being potentially exposed to COVID, will preside. Senate Republicans are willing to ignore the need for economic relief. They're willing to ignore the nation's testing needs. They're willing to ignore election interference, all so they can put someone on the highest court who would take health care away from millions of Americans in the middle of a pandemic. God save us. Now, only a few hours after Justice Ruth Bader Ginsburg passed away, Leader McConnell announced the Republican majority would move quickly to confirm her replacement. At the time, we didn't know exactly when, but now we do. Republicans are rushing to hold a confirmation vote tomorrow night, 8 days before the election. And after more than 50 million Americans have voted for president, quite possibly a different president, to pick justices on their behalf. After more than 50 million Americans have voted for senators, quite possibly different senators than some who are here today, to advise and consent. Confirming a lifetime appointment this late into a presidential election season is outrageous. It is even more galling, of course, because nearly every Republican in this chamber, led by the majority leader, 4 years ago refused to even consider the Supreme Court nomination of a Democratic president on the grounds, the principle that we should wait until after the presidential election because the American people deserved a voice in the selection of their next justice. My colleagues, there is no escaping this glaring hypocrisy. As I said before, no tit-for-tat, convoluted, distorted version of history will wipe away the stain that will exist forever with this Republican majority and with this Republican leader. No escaping the hypocrisy, but oh my, how the Republican leader has almost desperately tried. Over the past few days and weeks, the majority leader has subjected the Senate to a long and tortured defense of this cynical power grab. Madam President, can we please have some order? Thank you.
The Senate will be in order. Please take your conversations out of the chamber.
A long and tortured defense of this cynical power grab. The Republican leader claims the majority's position all along has been that it's acceptable to deny justices in presidential election years when there's divided government. But here's what Leader McConnell said after Justice Scalia died. The American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. He didn't say the American people should have a voice, but only when there's divided government. He didn't say the American people deserve a voice, but only when it serves the political interests of one party. Otherwise, we don't mean it. No, Republicans all swore this was a principle, their word, not mere incident of who controls the Senate and the presidency, and the transparency of this new excuse does not cover up the hypocrisy, does not change it one bit, and everyone knows it, everyone. And by the way, if this were about divided government, the senior senator from Florida would not have said he would, quote, say the same thing if a Republican president were in office. The junior senator from Iowa would not have said, precedent set, precedent set. I'm sure come 2020 you'll remind me of that. Chairman Graham would not have said, hold the tape. Use my words against me. You can say Lindsey Graham said the next president, whoever it might be, not whatever party it was in, should make the nomination. So the flimsiness, the transparency, the dishonesty of the excuse that they've come up with ex post facto doesn't work, doesn't work. So, no, this has never been about the orientation of the Senate and the presidency. Republicans promised they'd follow their own standard if the situation was reversed. Guess not. Now, the Republican leader claims that the majority's actions today are rooted in some convoluted precedent. The truth is, the precedent is clear and simple. The Senate has never confirmed a Supreme Court justice so close to a presidential election. The Senate has never even confirmed a justice between July and Election Day in a presidential year. I asked the presiding officer to confirm these two facts, and both were confirmed by the records of the Senate. There is no precedent, none, for what is going on here. And the Republican leader has claimed that the majority's actions are justified by all sorts of bad things Democrats did in the past and may hypothetically do in the future. He said that every escalation of significance in judicial debates was made by Democrats. Convenient, I guess. I guess significance is in the eyes of the beholder because the Republican leader's history conveniently and mandatorily to make his case, his false case, left out a whole lot of chapters, ignored. He conveniently admitted that Republicans bottled up more than 60 judicial nominees from President Clinton, refusing to give them a hearing in the 1990s. He made no reference to the decision by Republican senators to hold open 14 appellate court seats under President Clinton so a Republican president could fill them instead, a tactic Republicans would revisit under President Obama when Republicans used partisan filibusters to block his nominees to the D.C. Circuit. At the time, the Republican leader and senators from Iowa and Utah said that President Obama was, get this, trying to pack the court. Amazing, pack the court? They held up the nomination so President Obama couldn't have his rightful appointees to the second highest court in the land, and they kept a number of seats, I believe it was 4, vacant for such a long time? Well, we've heard all this before. It seems whenever the Republicans need to scare up some votes, they accuse Democrats of trying to pack the courts, even when it's a Democratic president invoking his constitutional authority to appoint judges and the Republicans blocking it. Now, Republicans tried to nullify President Obama's authority to nominate judges to the Circuit Court. And then, as soon as Republicans had a majority, they succeeded in nullifying his prerogative to have a Supreme Court nomination considered by the Senate. And what did Leader McConnell say about it? This remark will go down in infamy. He called it one of his proudest moments. Apparently, the blame game Leader McConnell wants us to play goes all the way back to 1987. That's the reason we're so hypocritical. What happened back in 1987, says the Republican leader. It all began with Robert Bork, he says, after Senator Kennedy gave a 3-minute speech that Republicans considered intemperate. Seriously, that is, according to our Republican friends, the original sin, according to the leader. A 3-minute speech. While we're on the subject of Robert Bork, I'd remind my colleagues that Robert Bork received a hearing and a vote in the Democratic Senate. His nomination was defeated by a bipartisan majority of Republicans and Democrats. Republicans helped defeat Bork, left out conveniently by the leader's recantation of history. His nomination was defeated, and President Reagan's eventual replacement, Anthony Kennedy, was confirmed unanimously. For those keeping score, Merrick Garland never even got a hearing. But because one Democrat gave a speech Republicans didn't like, the fight was on, according to the Republican leader. According to the Republican leader, because of that 3-minute speech in 1987, Republicans can steamroll the minority to confirm a Supreme Court justice in the middle of an election. Imagine trying to explain to someone, sorry, I have to burn down your house because of something one of your friends said about one of my friends 33 years ago. Yep, burn down the house because of a comment 33 years ago. That's what they're doing. Mr. President, the leader's speech, the Republican leader's speech, was schoolyard stuff. Here in the United States Senate, in order to justify an outrageous power grab that even some members of his party don't agree with, the leader's argument boils down to, but you started it. Any parent with young children would recognize that argument. It's when you know you've done something wrong, but you don't want the blame. That's exactly what the leader's speech sounded like to so many Americans. Let's get serious here. This isn't about the long history of judicial escalation or a 33-year-old speech. This is about raw political power. This is about a Senate majority deciding to break faith with the American people and make a mockery of its own principle to secure a seat on the Supreme Court. And let me dispense with one more fiction. The leader keeps claiming that Supreme Court seats have nothing to do with power or ideology. Judges and justices only apply the law, they claim. They only call balls and strikes. My Republican friends have told us over and over again that if someone is qualified, has good top-notch qualifications, they should be confirmed because judges merely apply the law. Well, if that were true, if Leader McConnell truly believed the only thing that matters about a judicial candidate is his qualifications, then Merrick Garland would be sitting on the court right now. His qualifications were every bit as good as Amy Coney Barrett's. Every bit as good. So all of a sudden, we should only judge by qualifications. I get it. I get it. So if it were true, once again, I will repeat it. If any of my Republican friends believe that the only thing that matters is the qualifications of a judicial candidate, Merrick Garland would be Justice Merrick Garland now. No one said Judge Garland wasn't qualified, but Republicans subjected his nomination to an unprecedented partisan blockade. If qualifications are the only thing that matters, why did President Trump vow to pick only justices who would terminate our health care law? Why did he say that his judicial appointments would, quote, do the right thing on health care, unlike Justice Roberts? Why did President Trump say if he gets to appoint 2 or 3 justices to the Supreme Court, Roe v. Wade would be overturned automatically? That's not qualifications. President Trump doesn't have a problem talking about how judicial appointments might rule when he's trying to win an election. But apparently Democrats are, quote, in the words of the leader, hysterical for even questioning how Judge Barrett looks at hugely consequential issues. I want the American people to know the far right is lining up right now to get the Supreme Court to review your fundamental rights because they think Judge Barrett might provide a certain outcome. President Trump and Republican attorneys general are suing to eliminate the Affordable Care Act in a case that will be heard 1 week after the election. 3 days ago, the President of the United States said on tape, quote, I hope that they will end it. It'll be so good if they did. Republicans in Pennsylvania have just appealed a split decision by the current Supreme Court that prevented an early cutoff to counting ballots. Just one vote on the court could change that outcome. The Attorney General of Mississippi this week filed a brief asking the Supreme Court to review a Mississippi law banning abortions after 15 weeks, an invitation for a new configuration on the court to revisit Roe v. Wade. So don't tell me the issues don't matter, only qualifications. We're talking about the lives and freedoms of the American people, the right to affordable health care, to make their own private medical decisions, to join a union, vote without impediments, marry who they love. And Judge Amy Coney Barrett will play a part in deciding whether those rights will be sustained or curtailed for the next generation of Americans. So I want to be very clear with the American people about what's going on here. The Republican Senate majority, America, is breaking faith with you, doing the exact opposite of what it promised just 4 years ago to cement a majority on the Supreme Court that threatens your fundamental rights. Don't forget it, America. Don't forget what's happening here, because it's a travesty, a travesty, a travesty for the Senate, a travesty for the country, and it will be an inerasable stain on this Republican majority forevermore. I yield the floor.
Well done.
Madam President.
The Majority Whip.
Madam President, the Democratic leader seems to think that this had something to do with a 3-minute speech 30 years ago. I don't know where that comes from. I can tell you that he has been involved in a systematic reversal of the long-standing precedent when it comes to the consideration of judges to the federal bench by the United States Senate. And I'm a beneficiary, I suppose you could say, in some strange way of that. That was a major issue in my campaign in 2004. We made it about the blockade that the Democrats in the Senate at the time, led by the current Democratic leader, had started against a whole long list of nominees put forward by then President George W. Bush. Well, I'll remind you of a few names: Janice Rogers Brown, Priscilla Owen, Miguel Estrada, Judge Charles Pickering. There was a long list of judges that were blocked at the time by the current Democratic leader. In fact, as the Leader McConnell has pointed out, it wasn't even sort of a random thing. It was a planned strategy to start playing politics with the federal judiciary, instigated by the architect, the current Democratic leader, who at the time was holding workshops and seminars about how they could politicize the federal judiciary and figure out new ways to block consideration of judges put forward to the federal bench by then President George W. Bush. So that was a major issue in that campaign season, and I would argue one of the principal reasons that I am here in the United States Senate. So it's and then of course when the chickens came home to roost and the same tactics were used by the other side in a previous administration, as was pointed out again yesterday by Leader McConnell, the Democrats decided to break the rules, to change the rules in 2013 to go to a simple majority to basically get and confirm judges on the federal judiciary. So we are where we are today, notwithstanding all the bluster that you just heard, because of a long, systematic strategy by the Democratic leader to block judges put forward by Republican presidents. But, Mr. President, despite all of what you just heard, tomorrow we are going to get to vote to confirm one of the most outstanding judicial nominees that I've had the pleasure of considering during my time in the Senate. Judge Amy Coney Barrett is eminently qualified for the Supreme Court. By now, her accomplishments are well known. First in her class at Notre Dame Law School, Supreme Court clerk, beloved Notre Dame law professor, outstanding scholar, circuit court judge. Americans, of course, got to see Judge Barrett's qualifications for themselves a couple of weeks ago during her Judiciary Committee hearing. For 2 days, she answered tough and probing questions from Democrats and Republicans, displaying a consummate command of the law and a calm and thoughtfulness that shows she has the kind of judicial temperament you want in a Supreme Court justice. Mr. President, since Judge Barrett's nomination, the tributes have poured in from across the political spectrum. I quote, "Barrett is highly qualified to serve on the Supreme Court," said Harvard law professor Noah Feldman, one of the House Democrat star impeachment witnesses. Patricia O'Hare, former dean of Notre Dame Law School, sent a glowing letter to Judiciary Committee Chairman Lindsey Graham and Ranking Member Dianne Feinstein. And the letter, and I quote, goes, "I was the dean of Notre Dame Law School at the time that Judge Barrett first joined our faculty. In that capacity, I was responsible providing an environment in which she could flourish as a young faculty member, but also for evaluating objectively whether she met the university's high standards for scholarship and teaching required for advancement. This proved to be the easiest task of my 10 years as a dean. Judge Barrett was and remains a stellar teacher, beloved by students, a brilliant and nationally recognized scholar, and a generous colleague. I am confident," she went on to say, "that if she is confirmed by the United States Senate, she will be an outstanding justice, brilliant, fair, impartial, and empathetic, and will serve to strengthen an independent judiciary committed to the rule of law." End quote. And Mr. President, Professor O'Hara also took care to note in her letter that she doesn't write glowing reviews for federal judiciary nominees on a regular basis. In fact, she said the only similar letter she has ever written was in support of Democrat nominee Elena Kagan's nomination to the Supreme Court. She went on, and I quote, "I feel every bit as strongly about Judge Barrett's qualifications for a position as Associate Justice as I felt about Justice Kagan. And while I have not always agreed with the American Bar Association's judicial rankings, they certainly got it right with Judge Barrett." And that's me talking, not the professor. Mr. President, I'm still struck by the testimony that the head of the ABA Standing Committee on the Federal Judiciary submitted to the Senate Judiciary Committee. The ABA Standing Committee on the Federal Judiciary is the body that provides the ABA's evaluations of federal judicial nominees. In his testimony detailing the well-qualified rating that the ABA gave to Judge Barrett, the head of the ABA committee noted, and I quote, lawyers and judges uniformly praised by the nominee's integrity. Most remarkably, in interviews with individuals in the legal profession and community who know Judge Barrett, whether for a few years or for decades, not one person uttered a negative word about her character. Accordingly, the Standing Committee was not required to consider any negative criticisms of Judge Barrett, end quote. Mr. President, that's quite a tribute. But of course, ratings of well-qualified do not just depend on character. They also depend on professional competence. And here's what the ABA's representative had to say about that. And again, I quote, "Given the breadth, diversity, and strength of the positive feedback we receive from judges and lawyers of all political persuasions and from so many parts of the profession, the Standing Committee would have been hard-pressed to come to any conclusion other than that Judge Barrett has demonstrated professional competence that is exceptional," end quote. And Mr. President, along with her character, competence, and command of the law, Judge Barrett brings a clear understanding of the proper role of a judge. She understands that the job of a judge is to interpret the law, not make the law, to call balls and strikes, not to rewrite the rules of the game. Or as Judge Barrett said in answer to a senator's question, "I apply the law, I follow the law, you make the policy." As Judge Barrett made clear in her hearing, she will be the kind of justice who leaves her personal beliefs and political opinions at the courtroom door. She will look at the facts of each case and judge according to the law and the Constitution and nothing else. Mr. President, when I came to the Senate, I hoped to have the opportunity to put judges like Amy Coney Barrett on the bench. I was proud to vote to confirm her to the Seventh Circuit Court of Appeals in 2017, and I look forward to voting to confirm her to the Supreme Court tomorrow. Mr. President, I yield the floor.
President.
Senator from California.
Mr. President, I rise today in opposition to the nomination of Judge Amy Coney Barrett to the United States Supreme Court. Just over a month ago, our country lost Justice Ruth Bader Ginsburg, a leading voice for equality and fundamental rights. Judge Ginsburg's nomination was the first that I participated in when I came to the Senate 28 years ago. At her hearing, I had the opportunity to thank her for all she had done and for all she had yet to do. Before she was confirmed to the bench, Justice Ginsburg played a critical role in breaking down barriers for women. During her confirmation hearing, she staunchly and forthrightly defended her positions as an advocate for equality, including her own support for a woman's fundamental right to control her own body, the core holding of Roe v. Wade. Excuse me. Once confirmed to the court, Justice Ginsburg worked tirelessly to ensure that the opening words of our Constitution, "We, the people of the United States," included all people, not just the elite few. So the stakes are extraordinarily high in confirming a replacement for Justice Ginsburg in the best of circumstances. But for Republicans to proceed now, just 8 days before an election, undermines, I think, the integrity and independence of the vote. Senate Republicans are breaking their own statements and promises by proceeding. In February of 2016, Republicans refused to consider a replacement for Justice Antonin Scalia because it was an election year. They blocked all consideration of President Obama's nominee, Judge Merrick Garland, claiming that the American people should have the opportunity to weigh in on a Supreme Court vacancy. Leader McConnell, at the time, clearly stated the Republicans' position. Quote, "My view, and I can now confidently say the view shared by virtually everyone in my conference, is that the nomination should be made by the president that the people elect in the election that is now underway," end quote. Well, That's clearly not going to happen. Chairman Graham, in 2018, reiterated this standard, promising that if, quote, an opening comes up in the last year of President Trump's term and the primary process is started, we'll wait till the next election, end quote. But when Justice Ginsburg passed away just 46 days before Election Day, Senate Republicans did not hesitate to go back on their word. On the night of Justice Ginsburg's death, Leader McConnell announced that President Trump's nominee for the vacancy would receive a vote on the Senate floor. And Chairman Graham immediately set committee hearings for October 12, giving the committee just 2 weeks to review Judge Amy Barrett's record. This proved to be insufficient, as evidenced by Judge Barrett's failure to identify and disclose significant amounts of material. Then, before Judge Barrett's hearing had even concluded, Chairman Graham held a markup on her nomination, and more rules were broken by setting a committee vote on her nomination for 1 p.m. the following week. I, along with the Democratic side, refused to take part in that committee vote. But this was not a decision that we made lightly. We were not willing to participate in any further in a process that was used to rush this nominee forward in the middle of this election. Despite our objections to proceeding, Democrats demonstrated through the course of Judge Barrett's nomination hearing what's at stake with her nomination, starting with Republican statements to use the Supreme Court to dismantle the Affordable Care Act and strip away health care coverage for millions of Americans. On November 10th, the Supreme Court will actually hear oral arguments in a case titled California v. Texas. That's a case challenging the validity of the Affordable Care Act. President Trump promised to appoint justices who will vote to dismantle this landmark law. In 2015, he stated, quote, "If I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare," end quote. When he nominated Judge Barrett to fill Justice Ginsburg's seat, President Trump stated that eliminating the ACA would be a, quote, "big win in the USA," end quote. And even more recently, in an interview with 60 Minutes, President Trump said he, quote, "hopes the Supreme Court will strike down the ACA, and he believes, quote, it'll be so good if they end it," end quote. Let us not forget, after all, that Justice Ginsburg joined a 5-4 majority when the Supreme Court upheld the ACA against Republican-led challenges in NFIB v. Sebelius and King v. Burwell. Like President Trump, Judge Barrett has criticized the upholding of the Affordable Care Act in FFIB v. Sebelius. She stated that Chief Justice Roberts, quote, "pushed the Affordable Care Act beyond its plausible meaning to save the statute." She also cast doubt on the Chief Justice's opinion in King v. Burwell and said that he departed from, quote, "the clear text," end quote, "of the statute to end gutting it." She likewise claimed that the dissent had, quote, "the better of the legal argument," end quote. At her confirmation hearing, Judge Barrett did not answer questions about her view on the ACA and did not meaningfully walk back her criticism of these two 5-4 Supreme Court decisions upholding the law. She also implied that coverage of pre-existing conditions is not an issue in California v. Texas. However, the Trump administration is directly asking the court to strike down the entire Affordable Care Act, including its protections for patients with pre-existing conditions. Let me be perfectly clear. I believe if Judge Barrett is confirmed, Americans could well lose the significant benefits that the Affordable Care Act provides. More than 130 million Americans, Mr. President, have pre-existing conditions like cancer, asthma, or even COVID-19, and they could then be denied coverage. At Judge Barrett's hearing, we heard the stories of real Americans who will be harmed and who illustrate what's at stake. This included a constituent of mine, Christina Monroe Garcia, who, because of the Affordable Care Act, received cataract surgery that saved her eyesight. It included North Carolina mom Stacey Staggs, who testified that the Affordable Care Act had ensured her twin girls receive life-saving treatments they needed. And it included Dr. Farhan Bhatti, a family physician working with low-income patients in Lansing, Michigan, who told the committee that opposition to the ACA, quote, endangers a lifeline that his patients count on to stay healthy and in many cases to stay alive, end quote. I deeply believe that Senate Republicans should not be moving forward on a justice who will likely help strip health care from millions of Americans, particularly in the middle of a global pandemic that has already taken more than 225,000 American lives. Judge Barrett also represents a threat to women's reproductive rights. President Trump has told us so when he promised to appoint justices who will, quote, automatically, end quote, overturn Roe v. Wade. And Judge Barrett has made clear that she would likely be the court's most extreme member on reproductive rights. At her hearing, she refused to state whether she agreed with the landmark case Griswold v. Connecticut, which established the right to use contraceptives. In addition, she would not affirm whether Planned Parenthood v. Casey, which upheld the constitutional right to abortion established in Roe, was settled law. And she stated outright that Roe is not a super precedent, indicating time and again that continued efforts by anti-abortion activists would provide the Supreme Court ample future opportunity to further limit or overturn Roe entirely. Now, this was a surprising departure from the last four Republican nominees, who acknowledged at their hearings that Griswold is, in fact, settled law, and that Roe and Casey are, in fact, important precedents of the court. Beyond these specific examples, Judge Barrett's view of precedent itself poses a continued threat to countless rights that Americans rely on and cherish. As an academic, she wrote that it is, quote, more legitimate, end quote, for a justice to, quote, enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it, end quote. Essentially, what that states is that she will feel free to overrule precedent that she believes conflicts with her interpretation of the Constitution. Judge Barrett's record also raises grave concern about how she would rule on cases involving voting rights and core democratic norms, In her dissent in the Seventh Circuit case, Cantor v. Barr, Judge Barrett suggested that voting rights are entitled to less protection under the Constitution than the right to own a gun. She distinguished between, quote, the individual right to own a gun and the civic right to vote. She argued that a felony conviction should not necessarily result in the loss of the right to own a gun, but emphasized that it may result in the loss of the right to vote. She even refused to say whether discrimination exists, even after being informed that Chief Justice Roberts wrote, and I quote, "Voting discrimination still exists. No one doubts that." End of quote. And despite President Trump's statement that he plans to challenge the results of the election in the courts if he loses, and that he wants his justice seated in time to hear those challenges, Judge Barrett would not commit to recuse from cases relating to the upcoming election. In addition, Judge Barrett's evasiveness at her hearing was deeply concerning. She refused to answer over 100 questions, not 10 or 20 or 30 or 40, but 100 questions, including basic legal and factual questions. Let me give you an example. Judge Barrett refused to confirm that the Constitution prevents a president from delaying an election. That's a hint. She declined to answer whether federal law prohibits voter intimidation. She would not affirm that Medicare is constitutional. She even hedged on whether presidents should commit to a peaceful transfer of power. And she would not acknowledge the existence of climate change. Judge Barrett's silence on these major questions really speak volumes. It demonstrates that a Justice Barrett will not be willing to stand up for core American values and rights, and raises additional concerns about her willingness to act independent of President Trump. In closing, it is my belief that Judge Barrett represents a threat to the very rights, including reproductive rights, rights of LGBT individuals, and voting rights that Justice Ginsburg worked so hard to protect. And for those reasons, I oppose her nomination and urge my colleagues to do the same. Thank you very much, Mr. Chairman. President, I note the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Senator from Illinois,
As consent, the quorum call be suspended.
without objection.
Mr. President, if you went across America